Welcome to Fraudcast, the podcast where we take a deep dive into the world of insurance fraud. How to spot it, how to detect it, and ultimately, how to prevent it. Today's episode, well, that's a bit of a bone of contention. We're talking about the curious case of Grubb versus Finlay, and asking the big questions. Will Scotland ever get its own Section 57? Why does England get to have all the legislative fun? And what will it take for Scotland to catch up? Joining me is a person synonymous with fraud fighting, a legal expert, anti-fraud lobbyist, and someone who treats a request for a quick update like a TED Talk, which is why we've had to make this episode a special two-parter. From Horwich Farrelly, the one and only Stephen Smart. Stephen, welcome to the Fraudcast, or should I say the award-winning Fraudcast. You're our first guest since we've won a prestigious award.
Well, now I feel the pressure to keep the quality up, Graham. Congratulations. I did actually ask some of your colleagues whether I should watch Frost Nixon for preparation for your questioning today, but they suggested Ali G instead, so I'll give you my comments at the end.
Okay, Stephen, we've talked before about the evolution of fraud. How would you describe where we are now in Scotland compared to England and Wales?
I think it depends in what context you ask that question, Graham. If we're talking about fraudulent activity, I think we're rapidly catching up. The level of claims and actors we're seeing come into the market per capita is probably actually getting much, much closer to what you've historically seen in the English and Welsh market. If you're talking about, I suspect, what's of more interest to you handlers in dealing with the claims, where are we in terms of legal remedies? We're still that way behind. The Scottish courts have definitely shown more of an appetite for wrestling with the issues, but we don't have any specific legislation, and we don't have that ability, particularly pre-trial, to be a little bit more on the front foot in trying to get rid of fraudulent claims.
Touching on that, could you give us a quick refresher on why Summers versus Fairclough was such a turning point for fraud litigation?
Yeah, well, as you know, I'm a bit of a counter-fraud geek over the years, and Summers v Fairclough was so important because it was the first decision where there was a direct acceptance. There was a right to strike out fraudulent claims. There was an acknowledgement that if people were going to abuse the court process, the court could use that power in extreme circumstances and dismiss claims. But more importantly, it provided that platform for the insurance industry to start saying, well, we need to get rid of these claims and save court resource and indemnity spend too. And obviously I know Zurich played a big part, were fundamental in going on and lobbying for what it was Section 57 in England and Wales, and just a much more educational awareness, I think, throughout the court system of the fact that fraudulent claims are remarkably prevalent.
Yeah. So you mentioned Section 57. What does it actually allow the courts to do, and why is it so powerful?
Yeah, so Section 57 gives you the power in the English and Welsh courts whereby if you can show that an element of a claim is what's called fundamentally dishonest, then the entire claim goes away. And the reason it's so powerful is it acts as a deterrent for people to put fraudulent claims forward. You're no longer looking at, well, just get a little bit reduced damages. I might not quite get as much as I've over-exaggerated. You are now putting your entire claim at risk, but it does put that pressure on people if they are going to put fraudulent elements of a claim forward.
Well, so in England, Section 57 gives courts a clear route to dismiss. What's the equivalent in Scotland, if anything?
You're just trying to wind me up now, aren't you? Unfortunately, in Scotland at the moment, we don't have a direct equivalent. Mm-hmm. Yeah. You go through the history of Scottish judgments, and there are very few directly grappling with the issues that fraudulent claims present. We don't have a statutory instrument that allows us to go, even in the most patently obvious fraudulent claim, to go to the court in advance of a proof or a civil trial as is and say this action should be dismissed.
Thanks, Stephen. So we've seen quoques introduced in Scotland. For us, how does that change the game for fraud cases?
Yeah, well for me, the biggest thing that jumped out at that was the provision to remove quoques protection for a fraudulent representation. It's the first time Scotland has had a statutory instrument in a civil claims context where the court has to consider the question, yes or no, has there been a fraudulent representation? Now, there's been discussion, obviously, it's a high bar to pass, but it lets us put the issue starkly before the court. There's no kind of fudging it about, just didn't quite have enough evidence to decide this, or it didn't come out in the right way in the day, the court has to, yes or no, address the question of whether there's been fraud. And we've seen that from the judgments. I think there have been more decisions in the last 6 years since Quox came into Scotland expressly addressing issues of fraud than there were in perhaps the 120 years before.
Speaking of decisions, could you talk us through a case where either Quox protection was removed or where it wasn't?
Yeah, well, I can give you a quick example of each. I mean, Zurich had the first written decision in Scotland where Quox protection was removed for a fraudulent representation. In Muzielowska, on the face of it, it might have just been a relatively straightforward claim, but as the evidence developed, it became clear that the claimant and her partner were both tailoring their accounts to fit the circumstances, and the court saw through that and called it what it was and made that finding to disapply Quox and let you recover your expenses or your legal costs in Scotland. We still see the odd case though where it feels fairly obvious to us and the court's just not quite prepared to go that far. One of my young colleagues recently had a fantastic result in Glasgow Sheriff Court where the sheriff repeatedly referred in the written judgment to sincere doubts about the credibility and reliability of both the pursuer or the claimant and the medical expert. But when it came to disapplying Quox, was just reluctant, said it fell just short of that test. We're still swimming through those judgments, finding that consistent path.
Okay, thanks, Stephen. We'll move on now to talk about one of the reasons why we're here, the Grubb versus Finlay case. So what were the key facts of that case and what made it stand out?
As you've heard me drone on about previously, Graham, I always say Grubb's the kind of Tartan Summers. It was a very minor road traffic accident on a petrol forecourt. The gentleman presented a claim for £500,000 of damages, the vast majority of which were future losses related to being unable to continue employment, etc. And what became apparent as the case progressed was there was a lot of evidence showing not just elements of perhaps subjective exaggeration, but just objective fraud. For example, one of the elements was that he'd indicated he couldn't drive because of his injuries, yet there were multiple driving offences which occurred after the accident. There was a tip-off given from a family member in respect of the fact that Mr Grubb was able to continue working when he'd indicated that he wasn't. There was CCTV footage showing that he was able to do things he had, not quite Kaiser Soze leaving at the end of Usual Suspects, but showing that an ability to carry out functionality beyond what was being presented to the court. So really the key evidence that came out was a number of things. Yeah, there was some of that subjective element, but there were a number of markers that just were objectively untrue.
Okay, Stephen, you mentioned there was a lot of evidence. From what I know of this case, there was CCTV footage. He even impersonated his dad, and there was even a tip-off from the claimant's brother. Despite all of this, the court didn't strike it out. Before you tell me why, I have to say, unfortunately, we've run out of time this time. So if you want to know the answer to this, practical implications for claims handlers and what the future looks like for Scotland, you'll have to join us next time. Welcome back to the hot seat, Stephen. It feels like only a minute ago we were last talking. So let's get back into it.
Let's go.
Okay, so the Grubb versus Finlay case. There was a lot of evidence. You mentioned CCTV, impersonation, and then even a tip-off from his brother, which will make for some very interesting family gatherings.
Going to be a nice Christmas dinner, that.
So despite all of that, the court didn't strike it out. Can you tell us why?
Yeah, so the court's rationale was that this came to light when the civil trial had already commenced. And the court took the view that it could make a determination on all of the aspects of the claim, hearing the evidence at the end, which, in itself would be fairly uncontroversial as a general principle. I think the frustration in that case is that it is such a significant exaggeration which led to such a huge amount of additional court time, expense, waste, doubt about what, how do you start separating what's true and what's not when you see that level of dishonesty. So the action was not struck out. In fact, Mr Grubb actually received damages for relatively minor physical injuries sustained, just none of the other elements.
In the ruling, the judge said that Mr Grubb lacked candour but wasn't fundamentally dishonest. So we've spoken about this before. Can you let us know what is the difference in legal terms? And more importantly, why does it matter?
Well, in terms of, they're not specifically legal terms. I think that's one of the things the appeal judgment goes on to explain. So the rationale was that there wasn't fundamental dishonesty, and the wording was he made a good if exaggerated claim. I struggle logically to understand that reasoning or how that separates. But the fundamental dishonesty isn't, as we've discussed, a statutory concept in Scotland. So I think the defenders in the case had made the submission that this was akin to that, and really the Scottish courts should take a firmer stance and not allow this to go forward. The lack of candour comment came out in respect of expenses. So again, Grubb very much followed Summers in trying to punish the claimant by making an award of legal costs against him. And that was the justification for it. Basically, the judge said, look, the lack of candour in presenting the majority of the claim is why I'm going to award costs against him. In relation to part two of your question, it seems to me we get ourselves that maybe that lack of statutory framework means we get into a little bit of a jumble in trying to explain why certain elements of the claim are being dealt with on the merits, but then having to apply the test for legal costs. It feels a bit contradictory to talk about a lack of candour, but then talk about a good if exaggerated claim.
Have things actually moved on since Grubb?
Yeah, definitely so. I think Quox was definitely a turning point for the reasons we've already discussed. We've had numerous judgments now in Scotland in the last 5 or 6 years where the Scottish courts, as I say, have directly addressed the issues presented in fraudulent claims. We had a case last year which was the first known reported decision where a Scottish court has held a claim was set up for insurance fraud, basically staged for the purposes of committing insurance fraud. That was just unthinkable. As you know, Graham, when we were starting all this 15 years ago, you just would not, I could not have come to you in good faith and said there was any realistic prospect that a court would reach that stage other than in the most extreme case. So we have moved on. We've seen numerous decisions where the Scottish courts have indicated, we've got a very professional, educated bench. They're not going to like when you've got clear examples of people trying to abuse the Scottish court process to make money.
Okay, thanks, Stephen. So moving on to the more practical implications for our claims handlers. For our claims teams and investigators, what should we be doing differently in Scotland when we suspect fraud?
I think there's, for me, two really key distinctions which your claims handlers have to have that understanding of, and your investigators too, Graham. The first one is how you collect and retain the evidence, because in Scotland we still predominantly have to have witnesses giving evidence at trial. So you need to have a clear system so that someone understands how they are obtaining and documenting that evidence, that they might have to speak to how they've done that at a trial, which obviously is not an easy thing to do. So again, people will be able to support you with that, but it's important that that's understood throughout the process. I think the second big thing to always bear in mind is how and when you disclose information supporting your position that it's a fraudulent claim. We don't have the same formality in Scotland at the pre-litigation stages like down south. We don't have statements of truth, for example. So you don't have that formal ability to hold somebody to a position and potentially be penalised for it if they are being dishonest further down the line. So you've got to be very careful about what position's being presented and not giving somebody, for example, the opportunity to explain something away or fudge it and get into subjectivity arguments, which might fall short of being held to be fraud when we pretty much know it is. Give you a quick example. We had a case this year where a claimant, they tried to doctor flight information to suggest that he hadn't been in a country on holiday when he was telling us he was incapacitated, having a great time on top of people's shoulders at a gig in Canada. We had the knowledge and the resources and we were able to get to metadata and to get to the information to show that the information had been doctored and the claim was abandoned. But that's the kind of thing I think you need that modern approach to claims handling to understand. That becomes vital in winning claims. We put that before a court without being able to evidence why we know it's fraudulent. It becomes a he said, she said all over again.
And on that then, is there a risk without stronger legislation that fraudsters might see Scotland as a softer touch or an easy target?
Yeah, this has been a bugbear of mine for a number of years, Graham, and I don't think you can rationally say we're not already seeing that. I've got one client just now who's dealing with rings of people coming across the border to have their accidents and then disappearing back down south before raising Scottish claims. We're seeing a number of new entrants to the Scottish market with no historical or frankly clear modern ties to the Scottish market, but all of a sudden setting up offices and bringing claims forward, when we know there is a really well-established Scottish claimant industry with a lot of reputable firms. So again, you query, I appreciate sometimes there are market forces, but it's a bit of a coincidence that this happens post-MOJ reforms and when we don't have those same tools to be able to fight claims that are perhaps questionable.
So what kind of evidence is most persuasive in courts right now, especially when trying to challenge quacks, just from a claims handler's perspective?
Yeah, I always think the most powerful evidence is objective evidence, first of all. You take the subjectivity out of it. Somebody has said, I couldn't do X, and you can objectively show they were doing it or it happened. even more powerful is when it is something from the claimant direct. So you get to social media, employment records, things like that, when there is just simply no explaining it away. When it's, look, the game's up, you've been shown. Witness evidence is still absolutely crucial, but increasingly intelligence and data-led evidence is very, very persuasive. If we're able to do things, for example, like ANPR hits and showing that vehicles which we're told aren't being used are in use, then the court has to ask really hard questions to accept the account that's been given by the other side.
That's encouraging. So you mentioned lobbying for a Scottish Section 57. What's the appetite just now in government for that kind of reform?
There's definitely an interest. I have to say that the response hasn't been, historically it's been a little bit lukewarm. There's been an interest, and not just in government, so we've lobbied other parties too. So there is interest in Parliament, and I think bringing it to life by showing examples. A couple of clients kindly gave us permission to give live examples of the kinds of cases they're dealing with, and it really hits politicians between the eyes when they see that, hold on a minute, this resulted in what payout? So there is an appetite, but certainly from parliamentarians there is an interest. I think in terms of the judiciary as well, as I keep coming back to it, the Scottish legal system, as you know, is separate and proud of its roots in history. And I think the bench, as they see more of these issues repeatedly coming round, there is starting to be that recognition of this is happening a bit too frequently for it to not be a thing. So I think there is. The difficulty, of course, the judiciary always have to be entirely independent, looking at a case-by-case basis. You can't go and plead that bigger picture case to people who have to decide individual actions.
Well, with an optimistic outlook then, if we did get a Scottish Section 57, what would that mean for the industry and especially fraudsters?
Yeah, well, I'd actually start the other way. I'd go back to your customers, first of all. It would give your customers confidence that actually when they place in their business with you, the Scottish courts are going to deal with these claims properly, and the payments they have to make towards their premiums are for genuine claims. In terms of your industry, it would make a massive difference in reducing indemnity spend, with the benefits that brings to you as a business and ultimately to your customers at the end. And for the fraudsters, it would send a really strong message. My fear at the moment in Scotland is there really isn't a very strong deterrent. We don't have civil prosecutions in Scotland for people who are caught blatantly putting forward fraudulent claims. The Procurator Fiscal Service, as we know, has a huge burden in Scotland and will take interest in serious claims, but we see the challenges they face in the most serious of prosecutions in Scotland, and it's just going to always come slightly below more serious crimes, in my view. I think it would set out a marker that you can't just hop across the border, to use my phrase earlier on, which I fear at the moment is something which is an attraction for bad faith actors. You
would be glad to know that this is the final question. So do you think we're close to a turning point in Scotland, or are we still stuck in 2009?
Well, I'm going to give you the most lawyerly answer ever, of course, and come somewhere in between.
Expect nothing less.
Of course, I wouldn't like to let you down, Graham. But we're definitely not stuck in 2009, in my view. We have seen from the number of judgments, going back to the comment I made earlier on, the Scottish judiciary realises when they're getting these cases before them, they're prepared to address the issues head on. There's no more kind of fudging it or dancing around it. They are prepared to address the issues that arise in trials head on. And the current president of the Supreme Court, Lord Reid, who was one of the judges who decided Summers against Fairclough, was so moved by it after 2009 that in 2012 he wrote a paper saying enough is enough in Scotland too. We need to be prepared to say, in cases where people are trying to abuse our court systems to fraudulently obtain money, to say, no, these claims get struck out. You're not entitled just to go to trial for the sake of it. And for me, we've still not reached that stage. So for me, that the lack of a provision to do that is the biggest weakness, I think, in the Scottish system. And, we'll hear friends in the claimant lobby who will sit around and say to us, but it's not a big thing in Scotland. We see the lobbying regularly about the fact fraud isn't the same in Scotland. Well, I was kind of throw back the chance. So what's your issue? We're all agreed in principle that fraudulent claims shouldn't be allowed to go forward. You're telling us it's not a big issue. Then what's the problem with having a provision so that if they are as few and far between as said, they don't get through our Scottish court system? I kind of feel like you end up with an episode of Yes, Prime Minister in the Cabinet where everyone agrees in principle there's a problem and then spends 5 minutes explaining why we don't want to actually do anything about it.
Brilliant. Thanks again for your time, Stephen. From what you've said, it seems like the future of fraud fighting in Scotland is hugely encouraging. I'd just like to clarify for those watching who have any concerns that Scott is still with us.
I was concerned. It did feel like this might be a memorial service, the poor man.
Thanks, Stephen.
Thanks, Graham.